Thank you guys for joining us today with Kyla and Greg from Varnum Law. My name is Laura Bryant. I am the Business Development Manager here in Southwest Florida for Castle Group. If you're not familiar with Castle Group, we are a full-service, full-time on-site property management company. So if you have any needs for property management, please feel free to reach out. Our contact information will be on the very last slide. But I'd like to introduce Kyla Thompson and Greg Wright from Varnum Law. Kyla, thank you guys. Greg, thank you for joining us today so you can educate us on the Corporate Transparency Act and what we need to know moving through 2024 as we prepare for the deadline on January 1, 2025. But Kyla, I'll let you introduce Varnum Law and tell us about you guys.
Sure. Thank you very much for having us here. My name is Kyla Thompson. I'm a partner at Varnum, and I represent many condominium and homeowners associations here in Southwest Florida, but I do represent them all over the state of Florida. Varnum is an office here. We have an office here in Naples, Florida. However, we are a national firm with offices as well in Michigan. We are a large firm with many resources, not only regarding condominium and homeowners associations, but also in corporate law and many other practice areas. I do have my partner here, Greg Wright, who will kind of introduce his background and provide us with more information regarding the Corporate Transparency Act.
Sure. Thanks, Kyla. My name is Greg Wright. I'm a partner with Varnum in one of its suburban Detroit offices. I've been practicing for about 18 years, and my practice focuses on mergers and acquisitions, general corporate matters, and also mobility, given my presence here in the southeastern Michigan area. One of the general corporate matters that's really come to our attention here in the last couple of years is the Corporate Transparency Act and the additional filing and reporting requirements that are going to be imposed on, largely small businesses and also, some small entities that, generally speaking, I think perhaps were not initially thought of as the target of this law, but are going to get caught up in it. And so that's one of the reasons that we're here today to talk a little bit about the CTA and the beneficial ownership information rule that accompanied it, how it applies to condos and homeowner associations, talking about the information that needs to be reported in order to comply with those rules, and then answering some of your questions. Hopefully, we'll have time at the end to fill in any gaps. Anything I'm missing, Kyla?
Nope.
That's it. Yeah. And I will be watching for questions as they come in, guys, and I'll filter them through you. So if you do have questions throughout, feel free to chat in our Q&A, and I will ask Kyla and Greg when they're on that specific topic. We did have some questions come in beforehand, and as we go through the presentation, when they're appropriate, I'll ask. If not, I'll wait till the end. All right, well, let's get started. And then if you guys are you guys okay with me sharing this in a PDF form, this presentation?
Sure.
To the attendees? Okay.
Yep.
All right, so we will email those out to those of you that attended.
Excellent. Okay. So first we'll talk about what is the Corporate Transparency Act. The Corporate Transparency Act was enacted on January 1st, 2021 as part of a larger defense authorization bill. It was actually passed over the veto of then President Trump. The CTA requires the collection of beneficial ownership information. We'll talk about specifically what falls into that category. The information relates to non-public companies. And the purpose of this act was to collect information that will help our national security, intelligence, and law enforcement agencies fight financial crime and other types of illegal or illicit activity. Generally speaking, a lot of this information has been collected, not all of it, but some of it has been collected at the state level where entities are formed, but it is not regularly updated. Not a tremendous amount of attention has been paid to it. And in terms of benchmarking us against sort of other jurisdictions in Europe and Asia, the amount of information that we collect in the United States that's available is substantially less. And so this brings us closer to in line with what some of those other jurisdictions collect and use. The Financial Crimes Enforcement Network, FinCEN, as we'll be referring to it throughout today's presentation, which is part of the U.S. Department of Treasury, had the job of promulgating the rules that achieve the purposes of the CTA and talk about the processes by which this information is going to be collected and the limited circumstances in which it will be provided for review. The final rule implementing the reporting requirements of the CTA was issued last September, and the law took effect on January 1st, 2024. Now, that said, the current calendar year 2024, implementation is limited to entities that are formed from January 1st going forward. So, I would expect that virtually everyone on this call will have interest in an entity, an HOA, a condo association that was formed prior to 24. You still have time. But the law is actually in effect and is impacting new entities already. And we can move on to our next slide. The BOI rule requires these certain legal entities, we'll get into which specific ones, but we're calling them reporting companies today, to file, unless we can find an exemption, certain information about the entity and the beneficial owners of the entity and company applicants. Generally speaking, the reporting parties, the information will be about natural persons, not legal persons. You won't be disclosing the names of other entities that own. You'll follow up the chain of ownership up to a natural person. Each reporting company created or registered to do business in the United States on or after January 2024 will have, actually, you'll see under this second point here, it's been extended to 90 days for calendar year 2024 to give folks a little bit of extra time. But going forward, everything is going to be 30 days. So once you form an entity, you'll have 30 days to get in the system. If there's a change to information, we'll talk about what that looks like. You already only have 30 days to put that in the system once you're in. This 90-day cushion is just sort of an upfront concession that was made last minute. Any reporting company that was created or registered to do business prior to January 1st of this year, as we said, has to file an initial report, meaning get in the system, by January 1st of 2025. And to be clear, because I've gotten this a lot, that 30-day cushion does not apply from January 1st. This year is the cushion. So you got to be in by New Year's Day. Violators of the CTA may be subject to civil and criminal penalties. We will talk a little bit about that later on. I'm sure that will be a point of some interest. So what is a reporting company? So a corporation, either for profit or not for profit, is considered a reporting company. A limited liability company is a reporting company. And any other company created by the filing of a document with a U.S. State's Secretary of State's office or a similar office, or with an Indian tribe. So effectively, if you're creating an entity under the laws of a U.S. state, you are going to be a reporting company. There may be an exemption for you, but you will be a reporting company. In addition, foreign companies that are registered to do business in any U.S. state or with an Indian tribe, they also file a document to do that. They get captured. My guess is that's probably outside the scope of what most of us are concerned about today. Mm-hmm. This captures U.S.-based condominium and homeowners associations because those are legal entities that are filed by the creation or are created by the filing of a document with a U.S. agency. And so that's why we're here talking about the application of the law to HOAs today.
Hey, Greg, there was a question that came in. So does this act apply to developer-controlled HOAs in Florida?
Yes,
Mm-hmm.
It does. Yes.
Yeah, I can jump in on that also. A lot of my clients will ask, are we actually a corporation under the state of Florida? I look at ourselves as a community, and we are a community together. You do have a document called the Articles of Incorporation. It incorporates you as a company, as a corporation in the state of Florida. Every year you file an annual report with the Secretary of State of the state of Florida. And so you would be considered a reporting company.
Right. Thank you.
Great. We can move on here. So the next question, now that we've established that entities that file these documents, for purposes of formation, including HOAs and condo associations, are reporting companies. The question is, are they exempt? There are 23 separate exemptions from the filing requirements of the Corporate Transparency Act. And if you are looking for a way to help yourself go to sleep at night, I can direct you to a lot of information about a lot of those exemptions. Regrettably, they won't be of much interest today, I expect. For a broader perspective, I'll tell you the sorts of entities that tend to be exempt. They tend to be entity types for which the sorts of information we're trying to collect under this act are already available. So a lot of public companies, for example, if you're a reporting company under certain laws in the United States, if you're registered and trading securities on, the New York Stock Exchange or NASDAQ, those entities, because of their ongoing filing requirements, already a lot of this information is available. And so to have it pulled into the CTA rubric wouldn't make any sense. And so they don't. Things like banks are exempt because there's a whole regulatory regimen for them. Financial institutions, registered investment advisors, broker dealers, insurance companies, all of that information is already available. The two here that are of general interest to sort of Main Street America, I think, one is called large operating companies. The idea there being that if there's a large operating company, you actually have a legitimate business operating through this entity, that the odds that it would be more difficult to use this for financial crime in the same way that you might use a small entity that doesn't have a lot of activity and it's simply being used to launder money or something of that nature. And so there are some requirements here involving number of employees and revenue, et cetera, that would trigger a large operating company exemption. Again, I don't think that's likely to apply to many of the associations we're talking about today. The area you might have expected to have an exemption for homeowners associations would be tax exempt entities. But the definition, the way that exemption is defined is pretty narrow, and it references what they call 501c organizations. So again, if you're feeling bored and you want to take a look at the tax code, there's this section called 501c that lists a wide variety of entities for which they are not liable for federal tax. And many of those entities also, you might have seen that reference where you're trying to make a charitable donation, because oftentimes you can then write that off of your own personal income tax return. 501c entities are generally speaking entities of specific kinds that provide external benefits broadly to the broader community, not to a limited community. And so there is actually a homeowners association reference in that section, but that is not generally applicable to homeowners associations as we understand them. Most of the HOAs that you're thinking of on this call are covered by a different section of the tax code, 528. It's equally boring, and regrettably, it is not an exemption under the CTA. I don't know whether this was an oversight. It kind of feels like it might have been. But regrettably, since Section 528 doesn't give us an exemption from this, we are on this webinar today talking about how to comply. And specifically, we've added here to the file just to maybe bring this home in a way that people who are working with compliance on these associations might understand. If you are filing 1120H pursuant to Section 528, there's your sign, I guess.
Greg, just
Oh yeah, go ahead.
Just to jump in here, most of our associations are familiar with 1120H and 1120 tax returns because that is the tax return that you all are filing every year, which means that you are under 528. I hear questions all the time, but we're a nonprofit corporation. Well, there's actually a distinction there because most nonprofit corporations, if not all of them, are 501c3 organizations. They're charitable organizations. As an association, Condo, HOA, co-op, POA in Florida, you are likely a not-for-profit corporation under Chapter 617, and you are not a 501c3 organization. So although it sounds very similar, they are different things. And I also receive questions a lot of, we are a large HOA, a large condominium association, and we have more than $5 million in gross revenues every year. We have more than 20 employees. And I guess the question then becomes, are they actually your internal employees, or are they employees under a management company? In this case, we're here because this is a Castle Group partnered webinar, which means that the employees are very likely employees of Castle Group, which would mean that it does not, this still applies to you and you are not exempted.
Yes, and Kyle, maybe before we leave this slide, I jumped over the large operating companies a little bit, but
Yeah.
just so folks understand this, this will generally be applied to small and medium-sized enterprises, but we're talking about companies that would directly, to your point, employ at least 20 full-time employees within the United States. They have a physical operating presence here in the United States, their name on a deed or their name on a lease. They're not working through they're not working remotely, everyone working remotely or working from a shared working space of any kind. And they've got a federal income tax return from the year before, at least demonstrating at least 5 million in assets. So it is possible that there may be a few people on this call who, maybe we could have a conversation about whether that applies to you, but it seems to me it would be rare for the reasons that Kyla laid out.
Right.
Yeah, and that's what a question came in from Brian saying, you use the term HOA. Does that include condo associations? So
It does. It does.
Yes.
Yeah. Yep.
All right, let's see. I've got a question from Roger on this slide. It's so 501c6 membership organizations are to comply as well.
Well, if you're under 501c, we would have to confirm, but the odds are that you may be eligible for an exemption. But if you are a not-for-profit that is filing an 1120H, you are probably qualified under the tax code under section 528, not 501c6, I believe.
Thank you.
So now we get to the meaty part of this. What information actually has to be reported to comply with the CTA? So the reporting company itself, so in this case, it would be the HOA, condo association, has to provide its legal name, any of its trade names or DBAs. I expect those may be rare in this context. A complete address for its principal place of business in the United States. Your jurisdiction of formation, there'll be a lot of Florida here, I imagine, or first place of US registration. That's more for foreign entities, probably not applicable here. And then your taxpayer identification numbers, which again, I expect will be off of your 1120H. The reporting company has to provide then for each beneficial owner and company applicant, which are terms that we'll get into here just shortly. These are individuals again, a person's name, their date of birth, their US residential address, usually not a business address, and then information from that person's passport or driver's license or state ID card, along with a picture of whatever, one of those 3 documents that you're using. Any entity that is created or registered to do business prior to January 1st of this year doesn't have to go the company applicant route. We'll get to that in a minute. Basically, a company applicant are people involved in the creation of entities. And so there was a recognition that if you have an HOA or a condo association or a company that's been around for 20 years, your ability to track down the person who filed the articles is going to be pretty limited. So that's not on your plate, but more on that later.
Got a lot of questions coming in, but I'm gonna wait till the end to see if we
Okay.
can cover.
Yes.
Well, before we move on to the next slide, I
Sure.
do have a question about this information that we have to report.
Mhm.
Are they official records of the association? Now, once I provide this information, I'm a board member. I'm now providing this information to the association, so the association or the management company can do a report and file this report. And that is a very big concern to a lot of our board members. Not only, a lot of this information, your name, your address, these can be found, but what about the information on your driver's license, on your passport, on your government issued ID? And as we know, under Chapter 720, Chapter 718 here in Florida, there's a list of what is an official record. And then at the end of that long list, there is a provision that says, it's basically your catch-all provision. Any other document that has to do with the operation of the association is an official record. So arguably, if you're going to provide that information to the association, it is an official record. And so once we discuss this and determine that it's an official record, then we have to make sure that that official record is protected, because we've got 2 kinds of official records. We've got the confidential official records and the non-confidential official records. And we have to make sure along with other information that you receive from other owners, like possibly their credit card numbers or maybe even their social security numbers upon purchase, that this information is shielded. I know, Greg, that there was some discussion regarding possibly being able to use a third-party company to hold this information so that the association might not be the entity that's required to shield it.
Yes, so, and I can provide some additional detail on that going forward, but there are a few ways to get around that, and I would recommend that associations look into this.
Yeah.
FinCEN itself is setting up, or has now established, because it's up and running now, the system, the beneficial ownership, it's BOSS, it's the boss. And the boss is collecting all of this information. One of the things you can do through the boss is individually, if you're a person for whom, the company needs to provide all this information, you can actually enter that system yourself, provide the information, and then get what is called a FinCEN identifier, which will then be, I assume, a numeric code. Think of it like getting a barcode or something, and you can provide that, that list of numbers or that code along to the reporting company. And then when they get to the point where they have to say, all right, well, I have to report, Greg's information, Greg just provides them with his FinCEN identifier. That way you're not providing all of this information to the condo association or homeowners association. Under Florida law, under the legal requirements associated with associations, it sounds like that is a big plus, because you don't have, creating official records to protect. But even beyond that, in certain circumstances, the information we're looking at collecting could be interpreted, under current law in some jurisdictions, or, if there's further development of the law, as personally identifiable information. And PII has, protection requirements associated with it in some jurisdictions as well. So, we're advising clients, if they can be strategic about this, to either work through this FinCEN identifier manner, function, or use a third-party service to collect that information sort of in the same way. That would really limit the amount of information you're collecting that you don't want to have on your own records.
Yeah, it would be a big liability for us too. We would, recommend the third party.
Yes, I had a call a couple of days ago with a client, admittedly a more traditional corporate client, who has a wide variety of companies and is requiring all of the individuals for whom he expects to need to report to go in and file, basically bring him a FinCEN identifier. Don't come to me with your personal information.
I don't want
come to
that.
me with your FinCEN
Yep.
identifier.
Exactly.
I think that's a good practice.
Yeah.
So speaking of folks who are going to have information filed, who are beneficial owners? There are a couple prongs of this. One is more obvious than the other. The first beneficial owner are people who beneficially own a portion of an entity. So for a more traditional for-profit corporation, limited liability company, this will apply. It'll make a little bit more straightforward sense. It would be an individual who owns either directly or indirectly at least 25% of the ownership interests of the reporting company. So if you own a small business and you have two people who own it 50-50, each of those individuals own more than 25%, and therefore they would be beneficial owners under that definition. If you have 5 people and they all own 20%, then none of them are beneficial owners for purposes of this prong of the definition. The other half is they're individuals who either directly or indirectly exercise substantial control over the reporting company. And there's some information here on a subsequent slide that gives a little bit more detail about what that means. However, they're individuals who, as directors or officers or contractually or otherwise, really have an impact on the decisions and the actions of the company. And we'll get into how that impacts working with your management company in a moment. But first, the first half of this, where we're talking about ownership, for a not-for-profit corporation, not quite clear here. I mean, most HOAs are organized as nonprofits, so traditional concepts of ownership don't make a lot of sense in this case.
Right.
You might have self-perpetuating boards, even if you're listed as a member. You probably don't own it in the same way. Your interest as you would if you own shares of a corporation, and so, as a direct matter, we don't think that's likely to be an issue. Analysis of who qualifies as a beneficial owner then is really going to hone in
Yeah.
on who exercises that substantial control. And we will get into that next.
There we go.
What is substantial control?
There you go.
Who exercises substantial control? So an individual exercises substantial control if that person is or functions as a senior officer of the reporting company. And we've got some names here listed up front. If that person has the authority to appoint or remove senior officers or a majority of the board. If a person directs or determines or has substantial influence over important decisions of the reporting company. So we've got listed here decisions about business, finance, and structure. All of that would bring you into this definition. Or such person otherwise exercises substantial control over the reporting company. So that very useful catch-all when you're trying to comply. But moving on here, I think our next slide talks about the types of senior officers. So, you know, these would be the sorts of folks in a traditional corporate context who would get captured in this definition. I know in condo associations, there are some analogies or some analogous positions here of folks who would get grabbed. And then depending on how your particular association operates, there may be others who serve functions that would, in another context, sort of fall into one of these roles. And those individuals would then be seen to exercise substantial control. It says a reporting company's treasurer or secretary who doesn't perform a similar function as these officers would be excluded. So just because you're, you know, required to keep records or that sort of thing, slightly different. But if you're taking high-level decisions about the direction of the association, actions it takes, its financial future, then you likely fall into that senior officer category, and you're likely to need yourself a FinCEN identifier.
I do want to go back to that previous slide, Laura, about the senior officers. And I want to make a distinction here because many of my board members, they don't necessarily understand the difference between being a board member and being an officer. So as Greg kind of discussed, you know, a lot of these senior officers must have this FinCEN identifier because you're going to be reporting. But the previous slide over, I mean, who has substantial control? Your board members are also making these decisions for the association. And so even if you are not the treasurer, or even if you're not the president or the CEO or the COO, as your hat as a board member, you would still be determined to have substantial control because you're making decisions for the association. And because of that, even if you're not the president, you're not the CEO, you're not the COO, you would still have to be somebody who is reporting under this rule. That begs the question. Right now, we are in the middle of annual meeting season, which means we're sending out our first notices of election to everybody to say, hey, if you want to run for the board, you have to be eligible for the board, but you need to let us know if you want to run. So the next question would be, should we put something in these first notices to say, not only do you not have to have a felony or had your civil rights restored for the last 5 years, you need to be eligible, not delinquent, you've got to certify yourself, and also you're going to be considered somebody who must report under this rule, which means you're also going to be, you should be ready to provide your name, your address, and all those identifiable information under this rule. And maybe that's something we need to consider because we don't want people getting elected and saying, well, I didn't really sign up for this, and then resign, and then we're going to have to report a resignation and then report an appointment after that. So that might be a best practice going forward, maybe not necessarily for 2024 because we don't have to really report until the end of the year. But next year for 2025, we're only going to have 30 days to start changing things. So, you know, it's something to think about for the next year.
It is something to think about, and it's making it, it can make it not appealing for people to want to be on the board, which is, it's hard. Yeah.
Our board members get paid big bucks to do this, you know,
They get a raise every year.
They get a raise, 100% raise every year. And it's tough for a lot of board members because not only do they have to, you know, deal with the issues that come with board membership every day and operating the association, complaints from our owners, but now we're the government and we're looking for all of this very should be confidential information. And I've got a lot of board members who've got issues with this.
Yeah. Yep.
Indeed. So it would be great if the substantial control definition just stopped at people who held certain specific titles or, certain individual specified functions. But that's not in fact the case. So any individual who directs, determines, or has substantial influence over important decisions made by the reporting company is also going to be captured in the beneficial ownership definition, and will have to provide their information. We said, business, finance, and structure are three areas where that control can be exhibited. And so, these sort of bullet points identify areas where, according to the guidance we've received from FinCEN so far, that sort of substantial control can be manifested. So if you're picking the types of, business lines or ventures or geographic focus for a traditional company, you would get grabbed here. My guess is that the business side here is unlikely to apply largely to associations, but the finances side certainly could. We see here, major expenditures or investments, incurrence of significant debt, approval of the operating budget, all seem like areas that could, be implicated by, traditional annual activity of an HOA. Compensation and incentive schemes, again, approving those substantial salaries falls into this category. And then the structure, maybe a little less in this case, but there are from time to time some organizational matters that arise that might need to be addressed. And if you have influence over those, either directly or indirectly, you're likely to become an important decision maker for purposes of this. And being an important decision maker might be appealing in another circumstance, but here it means that you have a compliance obligation.
Greg, I saw a question that came up. What about our non-US based or non-US citizen directors? Are they required to report as well?
Yes, there's no exclusion for individuals who aren't resident in the United States. So those individuals would have to, if they qualify as a beneficial owner, the entity doesn't have an exemption, so filing is required. You would have to file that information for them. If they are abroad, they don't have a U.S. driver's license, you would provide information from their passport and then upload a copy of their passport to the boss when you get your FinCEN identifier.
Okay.
Substantial control, direct and indirect. Again, a little additional wrinkle here. Individuals can have either direct or indirect substantial control through contracts, understandings, through relationships, through arrangements. And this is where we find an area that may be of some specific interest to folks on this call. So you can directly exercise substantial control by being on the board for a traditional company, by owning or controlling a majority of the voting power, or having any rights associated with a financing arrangement or an interest in the company. Indirectly, if you control an intermediary entity, again, not sure how applicable it'll be in an HOA context, but that would be one way, or through arrangements or financial or business relationships with others acting as nominees. So we're starting to wander into an area where we're talking about contractual relationships with other parties who may have authority to make decisions for the company, the HOA, the condo association. And at what point do those parties who are exercising those decisions have substantial control, and therefore they need to be reported as part of the reporting process? Move on to our next one here.
There we go.
Management companies. So that's the that I think is the issue here that is going to involve some additional scrutiny. FinCEN was kind enough to issue a number of responses to frequently asked questions. One of the ones that was issued asks if an unaffiliated company that provides a service to the reporting company by managing its day-to-day operations, but doesn't make decisions on important matters, is that a beneficial owner of the reporting company? So they answered part of this that initially that will be of less interest. It's, they say the unaffiliated company itself can't be a beneficial owner because a beneficial owner must be an individual. So they sort of sidestepped the initial question by saying, well, you need to find a person. It's true, so you'd have to perform the analysis going up the chain if this actually does apply. But any individuals that exercise substantial control over the reporting company through that unaffiliated company need to be reported as beneficial owners of the reporting company. But if those persons don't direct, determine, or have substantial influence over important decisions, or don't otherwise exercise substantial control, they might not be beneficial owners of the reporting company. So clear, right? Everybody
Yeah,
got
it's
that?
a lawyer's favorite answer. It depends.
Obvious, yes. So if I can try and distill this a little bit, the first part, which I thought was sort of a cop-out way to start it, is, well, the company isn't, you're not gonna report the company because the company is an entity and you need to find the people, you have to do the analysis at that company level to figure out which individuals you would list. Okay, that's an important point. But what I think we're here for is, specifically, if you have a contract, say with a management company that is handling a lot of the operations in the context of an entity that does not have many, or if any, full-time employees or the bandwidth to do a lot of these things itself, at what point does that management company or the individuals who you would report through it exercise enough substantial control that they themselves need to be filed? And then what are the implications of that determination? And so if you sort of, peer down the middle of this response, it basically says if they are directing, determining, or having substantial influence over important decisions. So going back to the slide we had before about business, finances, and structure, if those decisions have been functionally outsourced to a management company that has the ability to make those decisions for you, then we're looking at a situation where the management company has to be looked at as potentially, the source of some substantial control, and the individuals who control that entity would have to be reported. On the other hand, if the management company is effectively carrying out a series of services on your behalf and at your direction, and is not making those substantive decisions, then that's a completely different matter, and they may not be beneficial owners of the reporting company. Hopefully that was a little clearer than the response to that FAQ. But that's the best we have at this point. We'll try and illuminate that a little bit more as we move forward here. And I think our next slide's may have a bit on that.
Yep.
Oh, actually that is, we move on to BOI reports filed. So to sort of close the loop on that, I think that is going to be an interesting point to make a determination. What is your HOA's specific relationship to management company? What is the management company authorized to do? What are the types of decisions it is authorized to make in the course of its operation? If it is simply carrying out tasks on your behalf and at your direction, I think they probably are not going to be implicated in this.
Correct. And that's what most property management companies are doing. They should be. It's at the direction of the board.
Yes.
Yeah, I have some
say that now, wouldn't you?
Yeah. We are not making decisions for the board. Yeah.
Yes.
Right.
That is the point.
Yeah.
That said, if you have a contractual relationship with a management company that is unusual, or that involves making more substantial decisions than would be identified normally, this is probably a question that we would need to look into on behalf of a client like that to make that determination.
I did have a question come in from a self-managed community, and the CAM asked, does this apply to that person, the CAM, that oversees that self-managed community? And it depends on what you guys answer this. I would say it depends on what authority the board has given you as the manager. I've seen some managers that self-manage signing contracts and doing things like that. So if you're doing that, I would assume the licensed CAM that's at that self-managed community would also have to turn in this information.
Right. I mean, that's a great point, Laura, because we've got so many different types of associations and relationships with their management companies, and in your situation that you just brought up, the self-managed association. And, we've got some boards that are absolutely passive, that says, you know what, just come to us with a problem, otherwise operate the association. And in that situation, that CAM is probably going to have to be somebody who's going to report. We've got the complete other side of the situation where, CAM, you are only allowed to execute. We are making every single decision and you don't have any discretion. And so at that point, the answer is going to be, well, that person probably doesn't have to report. What we usually see is somewhere in the middle. And that's the tough situation, because where is that line as to when you have to report if you got a middle type of situation, meaning that we provide the CAM with some discretion to make decisions. Is it spending up to 1,000? Is it spending up to 10,000, 15,000? Where does it cross the line from I'm executing with a little bit of discretion provided to me from my board to I'm now making substantial decisions for the association, which means that I need to report. And I don't
And
know
those-
if we have that answer.
And those thresholds probably alone, you then probably have to compare that to the amount of assets involved, right? I mean, the threshold
Right.
then probably is compared, if you're dealing with a very small association, you may need relatively small thresholds of discretion to sort of stay within. A much larger association with a larger budget, down the middle thresholds, might be seen or viewed differently. So yes, this all unfortunately does go right down to the lawyer's favorite answer, it depends, but it does indeed depend.
It does.
So we can move on now, I think, to how BOI reports are filed. We'll talk a little bit about the practicalities of this. Like I said, the filings under the BOI rule are submitted through an online portal. We've got the URL here. It's the Beneficial Ownership Secure System. I've forgotten the full name, but it's the BOSS. And access to the BOSS is also available through third-party providers. So, for example, Varnum's working with a company called Single File to provide access for our clients, in part because of efficiency, in part because it's one step further removed from some of the personal identifiable information that we were talking about earlier that you're worried about for purposes of Florida law in particular. We talked a little bit about the FinCEN unique identifying number. Really do encourage folks to try and get individuals to use that, to encourage them not to provide you with specific information. I mean, aside from your requirement to protect that, when you put information like that in email, there's always the risk that something happens to it on either end.
Yeah.
And so to the extent that someone can go into a secure environment, upload it, get the information or get the code from FinCEN and just deliver that code, much better. That said, there is an updating requirement, which we're going to talk about on the next slide. So you can't allow people to think that once they've created this FinCEN number that they're set for life. There is going to be an ongoing requirement. Now, the last bullet here, we're not going to get into tremendous detail about this, but at least a little bit. There's always a question of, so they're going to collect all this information. What are they doing with it? You saw that it's a secure system. I've been assured that it's secure. It's in the name. And so, they've taken the industry leading efforts to make sure that this will be protected from unauthorized access. In terms of authorized access, FinCEN itself, law enforcement agencies upon a request can collect this information and, look into it to make a determination in an investigation as to who owns an entity, where funds may have been distributed, who would be handling it. Those can be both domestic and, in limited cases, I think foreign law enforcement agencies may also have access. The more practical side of this, certainly for our corporate entities, clients, but also for associations, financial institutions with client consent will have access to this information ultimately. I don't think that has necessarily been activated fully yet, but I expect in the coming year that will be more available. Now, the idea there being that, if you go out to get a loan of any kind, a financial institution, a reputable financial institution is going to perform a certain amount of diligence on you, know your client review. And I'm expecting that as part of that going forward, checking what is on file with FinCEN is going to become ultimately sort of a standard part of know your client diligence. They'll ask for consent, but if you don't provide the consent, then they'll probably politely decline to offer you the loan. If the information on file with FinCEN doesn't match what you've disclosed in the diligence information you've provided, in the certificates you've provided in connection with the loan, then there's going to be a discrepancy there. And my expectation is that if it's a mild one, you'd probably be given an opportunity to fix it. If it's a serious one, they would look into it, and it might be a reason that they decide not to move forward with the loan. I have to lastly add to this, that despite the fact that that's my sense of how this is going to be used, and a lot of my colleagues believe that that's how this is going to be used. I've met with a number of bankers and had conversations about this, and most large financial institutions have not yet set a full policy on how or if they're going to use this stuff. I expect it to move in that direction. I think we'll get more clarity by the end of the year. I've got a seminar next week that's going to talk a bit about it, so I'll have more information then. But we just don't know. Those should be those are likely, though, to be the circumstances, law enforcement and interaction with commercial lenders, where this information is likely to come into play. Do BOI reports need to be updated? Yes, they do. They need to be, unfortunately. Reporting companies need to report any change in the information that's required to be reported within 30 days of the change. Okay, so once you're in the system, regardless of whether you're early this year, if you're not required until January 1st, once you're in, the updating obligation kicks in. So this imposes an ongoing monitoring obligation on companies. So let's talk briefly about what sorts of things might require you to go back and fiddle with your BOI reports. Any change to the legal name of the reporting company. My guess is that you're not probably changing branding on an HOA very often, but if there's reason to do that, you would need to fix it. Any change of the beneficial owners, probably not beneficial owners in terms of ownership directly here, but keeping in mind a beneficial owner is also, we're also talking about individuals who have substantial control. So if you have an officer who falls into this category, someone on your board who you decide needs to be reported, or another individual who's providing some of these functions, if they pass away, if they resign, if they're replaced, that triggers a reporting requirement. You got to go remove that person, put in the new person's information. A change in the management company. If a determination is made that we need to report individuals associated with that management company, or if the terms or conditions of a management agreement, we go from a circumstance where the management company isn't doing very much to the fact that they're doing everything but turn the lights on in the morning. Then maybe we do have to look at that again. Any change of name, address, or the unique identifying number, that actually is referring to your driver's license or passport number. That triggers a requirement. So you get those FinCEN identifiers, then you go out, your driver's license expires, you get a new one. You have 30 days to go in, change the copy of your driver's license, update your address, update your driver's license number. You change jurisdictions, you cash in your Florida driver's license, you get a Georgia driver's license, you got to change that out. And you have 30 days in order to do that. And then any change in the exempt status of a reporting company. So again, we're working under the expectation that most HOAs will not be exempt, will need to file. But generally speaking, maybe if you're one of the few and the proud companies that might be able to qualify for one of those large operating company exemptions, if you lose a few employees, you fall below 20, the revenue is smaller, you start working remotely, you have 30 days to get on file with BOI. You will also have to continuously monitor for these changes that would trigger a reporting requirement. So just going to require some creativity. And also we have to think through, and I'm sure we'll discuss this a little bit, the recruitment and onboarding of directors and officers. So we talked about this earlier. There may be individuals who, for personal held beliefs, aren't interested in providing information of this kind to a government agency. That may not actually preclude them from service under Florida law. I know we've discussed that, but they may just, if they're informed of this, they may just not want to get involved. And so informing folks about these obligations up front seems like it would be, positive under the right circumstances.
Laura, how often do we have changes in board members and officers?
Definitely once a year, possibly 2 or 3 times.
Ideally.
Yeah.
Yes.
Yeah.
So
and this may cause an uptick, unfortunately.
Yeah.
It
Well,
may, and I mean, I think this will become. I was speaking with a partner of mine earlier today about this. My expectation is that this is going to just have to be for all sorts of entities part of its ongoing compliance obligations. I mean, certainly every year during annual meeting and report season, you'll have to collect this information, check it against what's been provided, and update it. but also, your policies and procedures for, removing, re-electing, moving people around. This is just going to have to be part of that process. You have to realize, oh, we also have to report
Right.
this to
Yeah.
FinCEN.
It'll be
I think
part of the
it'll
annual
become-
meeting.
Yeah, it'll
Yeah.
become easier once we do this for a certain number of years and once we become more familiar with the process and
Yes.
once we start educating everyone, which we're doing today, as to what the requirements are. And certainly something that one of my colleagues have said, there's no prize for reporting early, especially this year. You
No,
don't
and
have to do it
we'll
now
talk
or-
about that on the last
Yeah.
slide here. We talk about some practical considerations.
Right.
We are recommending that folks give it a little bit of time. Good time now to think through this and figure out what you're going to need to do, make a plan. But you're right. There's no prize for getting in the system early and undertaking all these compliance obligations immediately.
Exactly.
So
Yeah,
just
you
a
get
couple
what-
more here. The penalties. Here's the pain. So a person who willfully fails to file a complete initial report or an updated report, there can be civil liability. The fine's up to $500 a day, up to $10,000 overall, and imprisonment for up to 2 years. Do I think that they're going to come to your door and throw you in the back of the paddy wagon for failure to update your driver's license in the CTA BOSS system? No, probably not. However, we have no track record for exactly what they will do. The key word in this bullet here is willfully, right? So what does willfully mean in this context? Does it mean that you have to have knowledge of these requirements and say, darn it, I don't believe in this and I'm not going to provide it. I don't think it's right. Or understand that you're required to provide it and provide inaccurate or incomplete information? That's one reading of it. Is it simply that, this requirement's been out there for a while and you haven't made a good faith effort to comply? We don't have clarity on that. We would expect that enforcement of this will be limited by, the amount of resources that are going to be available to FinCEN and law enforcement, and also, hopefully by common sense, one would hope, but we don't quite know. And we would prefer that that entities avoid and officers involved with the company or the association avoid exposure to this. The next couple slides provide a little bit of additional information. If a person willfully causes a company not to file a required report or an incomplete report, that's definitely a situation we would look at as a potential enforcement action. So if you refuse to provide information knowing that a company couldn't file a complete report, you are sort of putting yourself out there as a more attractive target for enforcement. I will also note that there were initial copies as part of the development of this regime. There were initial copies of the forms circulated to the legal community and more broadly, and comment was solicited, and then updated forms were provided. The updated forms removed the capability to put in someone's name and then indicate, sort of shrug and say, but I can't get their driver's license. I can't get their information. I don't know this information. So your options will be to not file or to file without complete information, both of which would be a violation. And so you are, to some extent, by refusing to provide that information, you're putting others involved with the association at risk of legal enforcement. Liability does extend to senior officers. So again, we're looking at people who are volunteering to serve in these associations. And by not providing the information, even though you're required, you're putting them on the line a little bit. These are significant risks, and we don't want to discourage people from serving their community because we can't get this information taken care of. So that's the purpose of events like today, to get out in front of it. And finally, the practical considerations. So for individuals who are associated directly with the homeowners association, Florida state law may actually limit the ability of that homeowners association to take someone off the board or out of an officer role for failure to provide this information. Now, in a corporate context, we're working on language to put in governing documents, operating agreements, employment agreements, and policies to make it very clear to people who, from a corporate perspective, fall into these roles that, it's a condition to you owning a significant portion of this company or exercising this level of control or having this job, that if the company determines in good faith that we need this information, that you're going to facilitate compliance, either by hopefully providing the information directly and giving us an identifying number, or providing us with the information directly if that's what you insist upon. But that's in a corporate context. In an
Yeah,
HOA context, not-
that's tough. That's
Yeah.
a tough discussion to have, because
Mhm.
there are provisions in the statutes that say if you're no longer eligible, or if you are convicted of a crime or convicted of a felony, then you are removed from the board, or you're suspended for other situations. But there is nothing in the statute that says if you refuse to comply with the requirements of the CTA, you're also removed from the board. So now the question becomes, do we amend governing documents to put that in there? Are those amendments even enforceable? Because then it puts another level of being able to remove someone from the board that's not in the current statute. Could there be an argument that this would be a breach of fiduciary duty, because now you're stopping the association from being able to comply? That's a possibly good argument, but that doesn't remove the board member from the board.
And how much
so-
money do you want to spend on being the test case for that?
Right.
Exactly. That's a really, really good point. Yeah, it's a tough discussion here, because then I mean, again, our board members are paid handsomely for their jobs, and now they're being required to do all this. And then I guess the question then, the hard question for these board members to ask themselves is it worth it to serve on the board? And if the answer is no, and this is what I would tell all of the board members, if the answer is no, because you don't want to provide this information, then maybe you don't want to serve on the board. Although I know that most people are very noble. They want to provide service to their community. They want to be helpful. But if this is what's required to be a board member, then maybe you have to make that hard decision not to serve on the board, rather than put the association in jeopardy of not complying with a CTA.
So the only other point, I guess, here that we have on our slide is with respect to management companies. And in circumstances where you have a management company that is performing, that is really making substantial control type decisions like we talked about before, which we acknowledge may be rare. But if you have a more hands-on management company than simply one that is contractually obligated to provide or execute certain services at your direction and request, that may be a circumstance where you want to reach out to counsel, have them take a look at the arrangement, and then give you some advice as to whether or not you need to have a conversation with your management company about reporting. The difficult thing is, I would expect that most management companies will take the position that they're not exercising substantial control. This is an area where there could be a little bit of friction between you and your management company. Ideally, if you had a really hands-on arrangement with your management company, you might try and put something in the contract that addresses this issue. But one way or the other, if you believe that you have a more hands-on role for your management company than is standard, this might be something to look into. And again, like we talked about, the first part of this year is the time to ask those questions. If you wait until Christmas and try and file this material or get these questions answered, you're going to run into a lot of people who are trying to get these things handled. You're going to run into difficulty getting professionals in a lot of area to provide support, because year end is busy in so many areas already, and this will be just another one of those. However, if you file now, every time someone resigns from the board, or you get a change in a document, or somebody gets a new driver's license, this is going to become a headache at an earlier date than you want to encounter it. So analyze, think it through now, find folks to help you. And then in the last quarter, half of the year, that's the time to execute the plan.
Yep. And that's what we're recommending to our clients at Castle. And we'll be in touch with the boards early Q4 or end of Q3, advising what they're going to do. And we are using a third party. There's a website in which you can register, and they upload all your you can upload your documents there. But we are on this is our last slide.
That's it.
Yes.
Yeah.
Okay, but we've got a lot of questions.
Okay.
You tell me, how much time do you guys have? And let's see if we can, do
I have a few
quick
minutes.
wrap.
I'm happy to field
Yeah.
some questions.
Okay, let's field, just reiterating, this is kind of a recap too for some people that maybe came on after we started. So who's responsible for filing? Each individual, the registered agent, or someone else? We kind of already just answered that. It depends. It's going to be, it depends.
It depends, but the reporting company has the primary obligation, but liability for failure to file can extend to senior officers. And so everyone needs to hold hands and cooperate here to avoid, getting tagged.
Yes, I'm sorry, I'm reading through these questions. There's some people who have concerns about the hardship and what it's going to put on board members. We
Me
hear
too.
you, we
Agreed.
understand you. Yep, that's why they're still discussing everything.
Yep.
Um,
And by
all
the way,
right.
if I, Laura, very quickly, the other reason we're suggesting that folks wait until the second half of this year, there is some litigation pending right now with respect to the Corporate Transparency Act. It's maturing. It's reaching a point where we're expecting a decision. Don't cross your fingers for the entire regime to be struck down. It's possible, but we think it's unlikely. But it's certainly possible that there could be adjustments to this throughout the year. And why not wait until we have visibility of that? Point to bring to attention to.
Yep, very good point. Let's see, Carol asked exactly what address should be used, the mailing, which is usually the management company, or a physical address for the property.
So if we're talking about the
Fine.
reporting company now, not
Right.
the individuals. So yeah, the individuals generally has to be the individual's residential address. You can't
Right.
provide a business. For the reporting company itself, I'm expecting if it's got a physical office of any kind, that's the physical office you're going to have to use. If all of your correspondence is just running through a management company, I'm expecting you'll probably have to use that address if you don't have another one.
Again, somebody's asking again, do all board members have to register?
That's a tricky question too, because if you go back and look at, the slides where we talked about exercising substantial control, the question becomes, do you have the ability to appoint a majority of the board of directors? If you own, in terms of ownership, do you have the ability to make these substantial decisions? So if you're a three-man board, I think there's an argument that all three directors have to report. If you have a 5-member board, probably. If you have a 11-member board, maybe not, right? Because
Yeah,
one
but
vote
which
individually-
of the majority of your 11-member board has to report though? So that's
That was
the
one of the questions. Yeah.
all of them. I mean, the
Yeah.
question, I think ultimately, if all directors have the same amount of power, the same vote, which
Exactly.
they generally do, the question here is ultimately going to be, do directors have to file simply by virtue of them being directors or not? And so it'll be a straight up or down question of
Yeah.
whether the directors need to be on the roll.
Yep.
Yeah.
And that was a question. The next question was, if the board consists of 5 or more, can that mitigate the control issue? And that
I'm not announcing a hard number yet, but somewhere I expect in reviewing this and reviewing the specific decisions that are made by the board versus, the officers, there will come a number where there's comfort with that. And 5 may be on the low end, but higher than that, we may be able to let folks off the hook. Or I can't let them off the hook, but you might be able to achieve additional levels of comfort by not filing, put it that way.
Right. I think part of that analysis is the fact that most of our boards, you are 1 vote out of 5, out of 7, out of 9. And so your vote
Yes.
carries just as much as everybody else. So if you're
Yes.
only going to say, we have a 7-member board and only 4 have to report, I mean, which one's
Yeah.
going to raise their hand to provide that information?
Yeah, I mean,
don't know.
I'm one vote of many in the city in which I live. I might like to think I exercise substantial control over local government, but I don't. But in a small association, if I'm one of 7, I exercise
Right.
much more substantial control, albeit not direct, not total control.
Yeah.
So it's going to be somewhere between 60,000 and 7. That's where we'll have to draw that line.
right. Another question is, if the COA has a master association board and multiple sub-association boards, do the board members on the villa boards or the subs are they also required to provide their information?
That's a great question. I'll be happy to take this. Those are all different
Me too.
corporations, which means you are all different reporting companies, which means that every single corporation has reporting requirements.
Yep. Let's see. So, Paul, I'm just gonna read this as we go. Let's see, Paul asked, many significant financial decisions of a condo association are made by the members as opposed to the board. Are members / owners required to disclose? But the board executes and signs, the members may vote, if that's what he's referencing, correct?
If I can hit the "it depends" button, I think that's
Yeah,
probably
that's
where
what I was-
we're at.
Click.
Again, if the point here is that, the members get to vote on substantial number of large decisions, the question then becomes, how many members are we talking, right? I mean,
Right.
are the members, do we have a very small association whereby a member vote looks and feels and walks and talks a lot like a board vote might, with a small number of people where individual members exercise a lot of control? Then maybe that's a conversation we need to have. If we're talking about a very large condo association where you've got, one of a large number of votes, then you individually are not exercising substantial control, absent a really special circumstance.
All right, Robert asked, what about HOA committees, architect committees? Are committees included in any of this?
I probably wouldn't think so. Most of the committees in our condo and HOAs are advisory to the board. So they're advising the board of these, what the board should or shouldn't do, and are not exercising that substantial control.
Agreed.
All right, Carolyn had she had a big statement that this is a lot for volunteer board members.
Yep.
But what the question really is, what condo association crimes are they trying to prevent with this? Laws come up because there was a problem, right?
Sure.
So what triggered this?
Yeah.
Well, far be it for me to put my mind in the mind of a legislator. I don't know that there's specific. I don't know how specific it would be to condo associations. I think candidly, they drew up as part of the rulemaking and statutory process. They drew up a series of exemptions to the application of this law. And there were obvious ones, right? The public company, certain insurance companies and other institutions, nonprofit entities that are under 501c that offer a broad benefit. Those entities have certain filings with the IRS that provide to the IRS some of the information that is already required. My guess is that the fact that a lot of condo associations are filing, under 528 rather than 501c may have escaped some attention. If it's not just an oversight, it strikes me that it may be the case that, forming a small condo association might be an area where people could use the monies that are allocated or coming in and out of a condominium association where folks aren't paying very much attention to launder money of some kind. It must seem baffling to good faith volunteers who are just trying to keep their community operating. But that's my rank speculation. Kyle, you got anything better?
No, I was gonna say, board members got to stop money laundering.
Yeah.
Yep.
Mhm.
Jim asked, if someone submits a FinCEN number, how do we monitor future changes to driver's license? So
straightforwardly, you're probably not going to know when one of your officers gets a new driver's license. You're going to be relying upon your role in terms of achieving compliance is going to be to remind people to update that information as it comes, right? So, I think a couple of years ago, someone decided somewhere that when we change our clocks, we should all change the battery in our smoke detector, right? So that's a circumstance in which people are being reminded to comply with a requirement. I don't know what your batteries and your smoke detector look like, but I know that periodically they need to be replaced. So it may be helpful to have someone appointed on the board as your compliance officer to do things like that, to reach out to people periodically on a fixed schedule to remind them of this stuff. But yeah, I don't think, absent a real attempt to get into people's personal details, which I don't expect is coming, you're not going to know when someone moves, necessarily moves a residential address maybe within an association, or if someone gets a new driver's license.
Right. James asked, is there a cost of compliance to comply or file?
And there's not a cost to file in the BOSS system, but there'll be a cost to you in terms of your sort of time and potentially, efforts to assist on hard issues, but not costs, and there's no filing fee within the BOSS system.
Again, Richard asked, what the effective date of the CTA Act or CTA is, and we did answer that earlier, Richard. It was January 1, 2025. But
January
after
1st,
that, you're
2025.
late.
Yes, January 1st, 2025 for anything that existed prior to January 1st, 2024. So if anyone on this call is forming a condo association now, you're gonna have 90 days. The time is now.
Let's see. I'm just some of this we've already answered, and I don't want to have to repeat it again. Joe asked, would it be a breach of fiduciary duty, which you kind of touched on, and would most D&O policies exclude failure to comply with statutory regulations? So I'm guessing if they're asking if the D&O policy would exclude the board members if they were failure to comply with this requirement.
So that's a great question. I think there is an element of willfulness there. If you are failing to comply because it was an accident, I think you'll have some sort of coverage with your D&O policy. Your D&O policy really is there to protect you should you make decisions or forget or not do things that were not willful. And once, and as a board member, you are indemnified in certain situations as long as they were not willful. And I think that's the main word that we have to remember is, did you refuse to do something that that you were supposed to do, and you refused to do it, and you didn't want to do it, and you just ignored it. And once you step into that threshold, once you cross that line, then there's a very big question as to whether or not you're going to get D&O coverage, because that D&O is supposed to defend you in your everyday performance and operation as a board member. And once you cross into that, I willfully didn't do it because I didn't feel like it or didn't want to provide that information, then it's a very big question on whether or not you're going to get covered.
Jerry, you asked what Castle's position is. Again, we are advising our boards to look at this Q4 for sure, but we will most likely be communicating end of Q3 for next steps as we see what happens over this summer.
And Laura, to add to that, I think you may have mentioned this earlier, but it sounds like, at the risk of putting words in your mouth, your position is that generally speaking, a standard management contract with a condo association or homeowners association wouldn't involve the sorts of responsibilities we attributed as exercising substantial control.
Yeah, we're advisors.
That's an important point.
Yeah,
yeah,
we're advisors of the board. Board executes and we're advisors of, and we follow through with what they make decisions on and vote on. Yep.
Okay.
Laura asked, not me, Laura, asked how much fraud could a COA or an HOA perpetrate to make this kind of reporting worthwhile? There's been a lot.
There has been a lot. There has been a lot. But I mean, I don't think that there was an intention to make this applicable to condos and HOAs in particular. It is for all corporations throughout the United States. And so it wasn't like a spotlight on condos and HOAs. We just happened to be part of the mix. And so it's not necessarily that the US government thought that there was a lot of fraud and money laundering through condos and HOAs.
Yeah, I mean, to give an example, you can currently form, this will be part of my how to commit fraud. You can form, for example, a Delaware limited liability company by submitting a single piece of paper. You can have confirmation of filing back the same day. And all you have to report is the name of it and the person who signs the piece of paper, which may not have anything to do with the individuals who are running it. The state of Delaware, for example, will then have very little information on file, if any, about what the organization or execution of decisions is like. behind the scenes of that LLC. And that level of anonymity is of, value to many people, either, for legitimate reasons or illegitimate reasons. But people from other countries certainly look at that and they think that we're operating like an offshore entity here, or an offshore jurisdiction here where, there's no information available. And that's, I think, what this regime is intended to address, is just to have a certain amount of information available to law enforcement so that they can follow up and know what entities are doing. And HOAs just happen to be part of that mix.
Danielle asked, our elections are in November. Suggestion for getting this information to potential candidates that would take office in mid-November. Yeah, I agree with Kyla. I think it would be nice if, see what the summer says, what happens over these next couple of months. But I think it would be nice to say, here's what you're going to have to present.
Right. Yeah. Then they have a chance to determine whether or not they even want to run for the board.
Right. Lance asked, who is lobbying on behalf of the HOA board members? I know CAI is, correct? Don't they have a bunch of people up there fighting?
They might have a bunch of people up there. Hopefully, what they're doing will garner some results. I guess we'll have to see, and hopefully there'll be more advisories as the next couple months come.
Yeah. And again, people are asking, can we provide exactly what needs to be reported? We will be sending out a copy of this presentation in a PDF form to everyone who attended today. So you can see exactly what Kyla and Greg, digest all of it again. And I'm sure maybe later this summer, we should just do another webinar and say, here's where we're at. Here's what's in stone as far as what we need to do. Sorry, a couple more people are coming in. Maria, you said I missed the answer to this act. If this act applies to developer controlled HOAs, yes, it does.
It does.
Correct.
Yep.
Yeah,
Because it's not who controls it, it's whether or not you're a corporation and if you're exempted or not. And if you're not exempted, go ahead.
Yeah,
Greg.
I will add one, if I could just add one point to that. It is possible that if the developer entity, the actual entity that wholly owns an HOA, if it were a for-profit entity that were owned by it, there is a subsidiary exemption. So there is a possibility that if you have a developer that is a large operating company and wholly owns or controls this entity, that you may be able to connect dots in a way that might achieve exemption under those circumstances. But that's going to be a very specific analysis that you'd have to, reach out to counsel to confirm.
Yeah.
In
Again,
most
it
cases,
goes back to it depends.
It depends. Yeah.
All right. Joan asked, our elections are next month in March. Do we notify possible candidates for vacant positions?
Sure.
Yeah.
Yes.
Yep.
Yeah.
All right, guys, I think we are done. Great
Awesome.
conversation. Yep, this webinar was recorded. And again, like I said, I can send the link out with an email. So you can have Varnum Law's contact information if you have any further questions that they can answer on the legal side. If you need any help from Castle, we're happy to be here. But thank you guys, Kyla, Greg, thank you so much for great discussion. And we'll see what happens over the next couple months.
Indeed.
Ma'am, thank you so much. Have a great day.
Thank you.
All right. Thanks, guys. Take care.
Bye-bye.
Bye now.
Bye-bye.